Welcome. We will be starting the program shortly. We have approximately 750 registered attendees, so we just need to give the Zoom system a moment or two to admit everyone. We are offering live interpretation. Please choose the language you wish to hear the meeting in by clicking the interpretation button at the bottom right of your Zoom screen. You'll see a globe icon. If you are using the Zoom smartphone app, select your language by clicking More or the three dots in the bottom right corner of your screen. Then select Language Interpretation, then choose your language and tap Done. If you wish to hear only the interpreters and not the original speakers, be sure to select Mute Original Audio. Carola.
Buenas tardes, bienvenidos. Vamos a comenzar en breve. Si desea escuchar la interpretación en español, haga clic en el botón de Interpretation o Interpretación en la parte inferior derecha de la pantalla Zoom. Verá un icono de un globo terráqueo. Si se está uniendo a través de la aplicación Zoom para smartphone, para teléfono inteligente, seleccione su idioma haciendo clic en More o Más, o en los tres puntos en la esquina inferior derecha de la pantalla. Seleccione Language Interpretation o Interpretación de idiomas, luego elija Spanish o Español y haga clic en donde dice Done o Listo o Finalizado. Si desea escuchar solo a los intérpretes y no a los oradores originales, asegúrese de hacer clic en Mute Original Audio, es decir, silenciar el audio original.
Good afternoon. My name is Lisa Burke. I am the New Jersey Judiciary's Diversity, Inclusion, and Community Engagement Program Coordinator and will serve as the facilitator for today's program. Before we begin the program, I want to share a few notes to enable everyone present to have an optimal webinar experience. As a reminder, we are in the Zoom webinar platform, so all attendees are off video and muted. If you have any unlikely technical issues, you can exit and re-enter the seminar using the link you received. This program is presented as a virtual workshop, so we have several ways in which attendees can ask questions during the program. We have both the Q&A box and the chat box. We recommend you submit your questions via the Q&A box. If you are attending and listening to the simultaneous Spanish language interpretation, you can write your questions in the Q&A box in Spanish. You can submit your questions at any time. We will endeavor to answer as many questions live as we can, so we may merge some questions together. As a reminder, this is an informational session, so we cannot address individual cases. The chat box will also be used by the backstage production staff to provide information to you, such as links to online resources that our presenters reference. Finally, for any members of the press that are present, we ask that you please present your questions directly to Pete McAleer or Marianne Spoto. And now it is my privilege to introduce the Honorable Glenn A. Grant, Acting Administrative Director of the New Jersey Courts, who will offer a welcome and introductory remarks. Judge Grant.
Thank you, Lisa. Good afternoon to everybody attending this session. This is part of an ongoing dialogue or conversation that the New Jersey Judiciary is having with relevant participants, residents, landlords, legal attorneys, all involved in the landlord-tenant area, to update them and inform them about the ongoing efforts of the New Jersey court system to address the catastrophic issues dealing with landlord-tenant matters. As you know, the COVID-19 pandemic created extraordinary challenges for all of our society. It put extraordinary pressures on tenants who lost their employment, but equally, landlords were faced with some challenging circumstances as well. The initial harm to the tenants triggered a significant challenge to landlords because they weren't able to pay their mortgage, their insurance, their real estate business. And on top of these economic harms, many people suffered and continue to suffer continuing consequences related to illness or loss, tragic loss of life due to COVID-19. The circumstances are tragic, and candidly, it is up to all of us to come up with a plan to minimize further harm and to move towards a better future. Among the key points that I would like to emphasize this afternoon is the first dealing with the leadership of Chief Justice Stuart Radner in the Supreme Court. The court has been dedicated to trying to provide as much information as possible to relevant parties about how we're going to handle this significant number of pending landlord-tenant cases, and equally important, the number of unfiled cases dealing with landlord-tenant cases. We've had ongoing collaboration and support from the Department of Community Affairs, the legislature, and the other two branches of government. Clearly, DCA has a very critical role to play, and you'll hear more about them in their conversations with regards to rental assistance and funding that may be available to some of the state's residents and landlords. I would also recognize the court in another way. I had the privilege of serving as the chair of a special landlord-tenant committee that made significant recommendations to improve and transform how landlord-tenant cases were handled in our state. The participants in that committee, again, were representative of both landlords and housing advocates, and I believe we came up with a better way of how we process and handle these cases, particularly as a result of this pandemic. There are, however, an ongoing responsibility that we have as a court system to try to allow people an opportunity to resolve their cases amicably without necessarily going to trial. In order to do that, and particularly in this case, we're talking about connecting people to potential rental assistance. The goal here, working in collaboration with not only DCA, but county government, local government, and even some nonprofits, is to try to assist tenants who are facing, and landlords who are facing this challenge, to try to assist them in becoming aware of funding opportunities for rental payments to landlords. In order to support landlord and tenant cases, we believe that the best option is to have the parties come to a resolution without the necessity of going to trial, without necessity of the trial judge making a final decision. We will do so if necessary, but that is not what we're trying to do. We serve as a neutral party. We, the court, serve as a fair and balanced forum for the parties to come together and to hopefully resolve their cases amicably. What we're also recognizing is because of the challenges of getting funding immediately available to tenants and landlords, we are going to adjourn any case where the landlord or tenant can demonstrate that they have filed an application for rental assistance and that application is pending. We want to ensure that we move these cases expeditiously, but we also want to move them fairly and responsibly. To facilitate negotiations between the parties to resolve pending cases or new cases, if rental assistance is not received, we will then proceed with those cases in a manner that allows for, again, a process that will allow our landlord tenant specialists to assist in mediation, to assist in settlement conversations. Just yesterday, new legislation was signed by the governor that will provide options for some tenants to have their cases dismissed with a note from the DCA, with a certification filed with DCA that will be shared with the court, indicating that they have a pending application. The judiciary's longstanding policy of providing time for amicable resolutions in lieu of a trial has also been reaffirmed in a notice to the bar that was presented, that was published this afternoon. As you can see, this is a multi-pronged effort that we're working with executive branch, legislative branch, and other governmental leaders to try to provide financial assistance, to help people get financial assistance to resolve their cases. We're also working with advocates on both the landlord side and the tenant side to try to provide legal representation whenever possible. We're also trying to ensure that the cases are resolved satisfactorily, as amicably as possible. So this multiple effort reflects, I believe, one of the strengths of New Jersey. When we are faced with a challenge, we come together and we collaboratively try to address it. And this is one of the best examples of that, where you're presenting, in this particular case, millions of dollars to help landlords and tenants hopefully resolve their cases. With respect to the webinar itself, DCA will discuss more particulars about how you can access their funding. But more importantly, this crisis brings together the intersection of all three branches of government, private sector, everybody involved, again, trying to resolve this way where most people can stay in their homes, where most people can continue to be productive residents of our state. We will, as we have always done, review and analyze ongoing legislative changes, such as the one that was recently announced by CDC, and we will make appropriate changes to our policies if necessary. As I said, this forum is just one of the examples of our ongoing efforts to educate and inform all parties about the opportunity for funding assistance, the opportunity to come together to resolve their cases, the opportunity to educate both parties, if you will, about resolving their cases in an amicable way. This is not the only forum. We will have additional forums discussing these matters. We will engage in ongoing outreach efforts. We will be developing brochures that we will share with both landlords and tenants about this process. And we feel fairly confident through the collective efforts of all of you, through the collective efforts of the partnerships that we have established, that we can make a significant dent in the number of cases, the number of individuals that are facing this housing crisis, and hopefully, as I said, resolve those cases in an amicable way and to keep our residents in their homes. And with that, I will turn it over to Ms. Burke again.
Thank you so much, Judge Grant. Now to start the presentations. The first informational presentation, which as Judge Grant noted, will cover legislative changes and available funding resources, amongst other important points of information, is presented by Department of Community Affairs, Director of Housing and Community Resources, Janelle Winter. Director Winter.
Good afternoon. Thank you everyone for attending this, and thank you to Judge Grant and his team for all of the collaboration that we've had really since the beginning of the pandemic. And we are really grateful for it at DCA, and I really feel that we have the opportunity not only to address a lot of the challenges we have right now, but to help create a platform and a system that will work even better going forward. I wanted to talk about two things today. The first is some eviction protections that are available in the bill the governor signed yesterday, as well as rental assistance and assistance with arrears that's available through DCA. For the first, the eviction protections that are available, in the bill, it established that if residents self-certify for these protections, if there are residents who are middle income or below, and that's defined as less than 120% of their area median income, they are protected from eviction for any arrears that accrue during what's called the covered period, and that's March 1st, 2020 through August 31st, 2021. And in addition, can't be evicted for any non-payment of rent through August 31st, 2021. For those residents who are moderate, low, or very low income, they are eligible for additional protections if they also self-certify that they've applied for rental assistance and that they have experienced that they've experienced an economic impact from the COVID-19 crisis. And that is that in addition to the protection from being evicted for arrears accrued during the covered period, they also, if they miss rent in September, October, November, December of this year, they cannot be evicted for that as well. And their protection from eviction for non-payment through December 31st. And so January 1st, 2022 would be when they could first be evicted. And so in order to do this, what the legislation calls for is a self-certification by the tenant. Without that certification, then those tenants don't have that protection. And as we talk about this, it refers to, things like area median income, which is not really something people know just off the top of their heads, off the back of the chart. So what we've created is a tool that's available to help people determine if they may be eligible for these protections and to help generate a self-certification form that they file with their landlords, and then also if they're in an eviction proceeding with the courts. This is available online, and it's basically a simple tool that asks a few questions. It asks about where you live and your contact information. It asks about the size of your household, because that is part of the how we determine area median income. And it asks about how much money that you make. And basically I should have started with this, but to summarize a little bit, area median income is basically the median income in the area in which you live. So the different income levels are set based on what people make in the area in which you live. And most of our areas are the same as counties. And so what you will do if you self-certify for this tool, if you self-certify, if you are also below 80% and you self-certify that you've experienced an economic impact from COVID and that you've applied for rental assistance, then you are also eligible for the extended eviction protections. Once you do that, once you answer these questions, the form will generate a letter, a self-certification form that we ask you to review and make sure that it says, that those are accurate, the things that you stated are accurate. You type your name to sign it, again, certifying that it's accurate under penalty of perjury. And then if you have a pending eviction case and you go and you know your docket number, you can enter that, and then the form will automatically be sent to the court, and then you will give it to your landlord yourself. It will be emailed to you. You can also print out a copy and you will give it to your landlord yourself. If you're not in a pending eviction case, you give it to your landlord right away, and then you can hold on to it. Now, some people might not have access to the internet, or they might have access but have questions about this, whether just questions in general or a question about the process or a question specifically about the form when you get there. So what we've done there is we've set up a call-in number where you can ask questions, or you can actually file it right over the phone. You can give the information, you can certify it over the phone, and then it will, if you don't have an email address, it will be mailed to you so that you have a copy that you can give to your landlord and that you can keep for your records. And that number is 609-490-4550. And the best way to access the website is to go to nj.gov/DCA, and you'll see a link there for are you protected? Are you a renter who needs protection from eviction? And we really stress people, we really want people to go and file this self-certification as soon as possible. Even if you don't have an eviction case pending, we want to get those self-certifications in, because you are not, you're not protected if you don't file that information. I'm going to repeat the number again. We'll also put it in the chat. It's also available on our website too, and on the self-certification website. It's 609-490-4550. And as I said, it's right up on our website. If you go to the website and go to the page for this, you will also see FAQs. So there are a bunch of questions there. It does things like explain the different area median income levels, helps you understand what protections are there, answers just some of the questions that we anticipate people might have. And we go ahead, and if people have more questions, we'll add them there too. And so you can go to our website and follow the link for the income self-certification form. It's available in English and in Spanish. And again, the best way to go is to nj.gov/DCA. The second thing I wanted to talk about a bit is rental assistance that's available for landlords and tenants. Because while what this form does is it can provide a protection from being evicted for arrears accrued during a certain period, that money is still owed to the landlord. It becomes civil debt. So it's not as if this money is forgiven, it is still owed. Someone who files and is eligible for this protection just can't be evicted for it. But we do want to do our best to make sure that the rent gets paid. So DCA has an existing program funded by federal funds that we call CVRAP 2. And again, you can go to nj.gov/DCA, and there's a link to apply for this assistance. The initial pre-application is very simple. It asks you for some contact information, some information about your household, some information about your rent. It asks if you've experienced an impact from COVID. It asks, do you need arrears paid? Do you need future rent paid? So maybe you've been able to pay your rent, but now you can't, and you can't keep going. So you need help paying your future rent, or do you need both? And so you can click any one of those. And you can file that information. And then what we are doing is every day we draw what we call a lottery. We go in and we draw according to preferences from everyone who's in the pool. And we contact people and ask them for some additional information that we need to process their application, including information that's available about your landlord so that we can make a check or we can make an electronic payment. And you can apply as a tenant on your own behalf, or if you're a landlord and your tenant gives permission, you can apply on behalf of your tenant. So, and then the payment is made directly to the landlord, except in a few cases. And one thing to remember is that in New Jersey, we don't allow discrimination by source of income. So landlords are required to accept these funds and to participate in the process. And if there's a case where a landlord doesn't, one of the things that we do is we do call landlords and kind of explain the requirements, explain what they're required to do. But in a rare case where a landlord might not want to participate or isn't, we have the ability to make a payment directly to the tenant, who can then use that to directly pay the landlord. That's not the first option, of course, is always to try and pay the landlord. But if we need to, we can go ahead and make that payment. And we actually have done that in a few cases. So there is always that available if we need to get there. We do a lot of work every single day with our call center. The number I gave before is the same as the number for the self-certification. You can call there. And if you have questions about the process, you can ask them. And if you don't have internet access or you're not comfortable using the internet, you can make your application right there over the phone. So that's available, and that call center is staffed in English and in Spanish. And we have access to translation for 8 other languages as well. And the materials are available in 10 languages. So people will have access to that. And what we really would encourage everyone to do, if anyone has missed rent or is in danger of missing rent, is go to the website, do the self-certification form. And the self-certification, you just go online, you answer a few questions, and then you don't have to upload any documents. It's a self-certification. You sign it and you can print it out and you can give it to your landlord, save it for your records. Then there's that protection. And then you can go ahead and click on the button to apply for CVRAP, for rental assistance. And we have, from the federal government, we've received an allocation of first $353 million. Then we received an allocation for another $272 million. In terms of funding we've sent out in the past year for COVID-related funds, we've sent out over $250 million in assistance to help people stay in their homes, and assisted 30,000 households, and more every single day. We're doing more and more every single day. People can apply. We don't require documentation to apply. That's not something we ask for. And we are working every day to notify people, and we can get these funds out as quickly as we get a full application in. So when we contact you, make sure that you get back to us as quickly as possible. And if you have any questions or you're not sure, you don't have a document, go ahead and call us so we can help you. we do check runs every week. So we are going ahead and every week we send out checks to landlords. We've done payments for more than 30,000 at this point, and we'll continue to do that. The other good news I want to throw in is that in the bill that was signed yesterday, it allocated another $500 million for arrears and for forward rental assistance. We're going to use the same application portal and process to go ahead and apply for that. So if you've already applied for CVRAP 2, you've already applied for these funds. If you haven't, you just go and it's one application and you apply for it. So we're really, really excited to be able to have these resources available to people because we know there are a lot of people in need right now. And we are doing our very best to get this money out as easily and as quickly as possible. And I just want to encourage everyone to encourage people to self-certify that form so they can get protection from eviction and to go ahead and apply for rental assistance so we can pay landlords, we can get rent paid, both arrears and future rent, and ensure as many people as possible are able to stay in their homes. So just want to encourage people to do that and to call our number or to email in or go to the website for any questions. And I think that will end it for me right now.
Thank you very much, Director Winter. I do want to acknowledge that we have a number of questions that have come in that are DCA specific, but as we planned, we're going to hold the actual asking of the questions until the end of the program, so we will definitely be circling back to you. Before we move to the next presenter, I would like to make one announcement for the attendees. We know that there are many questions and we want to be sure that we don't miss any. So I'm going to ask if you would be kind enough to please submit questions to the Q&A feature, and let's hold the chat feature for us to drop the resources that our presenters are referring to as they make their presentations. We want to be sure that the resources that we're providing you do not inadvertently get lost in the string of questions. So it'll make it more efficient for you as the attendees, and it'll help us to ensure that we don't miss any important questions either. So next, I would like to present Attorney William Thompson III, who is going to speak on the rights and responsibilities of landlords. Attorney Thompson.
Thank you, Ms. Burke, and good afternoon, everyone. The landlord-tenant field is changing daily, including, as Judge Grant indicated just yesterday, a major change. And of course, that also says that the panelists, including myself, have only had 24 hours to try and understand all of those, and I'll try and relate those as best that I can. So before I start, though, I think it's important to tell landlords and tenants that the key to going forward in landlord-tenant law is to understand and adopt technology. Part of the Landlord-Tenant Committee that Judge Grant referred to recommended that future proceedings in landlord-tenant be held remotely, and the Supreme Court has adopted that recommendation. So you will be on your computer, your smartphone, your tablet, much more than going live to a courthouse. And the more comfortable you can be with that as a landlord or a tenant, the easier it's going to be for you. There's a lot of reference to the new law that took effect. As I said, I'll try and discuss that as best I can, but for everyone's information, the bill is Senate Bill 3691. That's S 3691. And if you go to the legislature's website, you can get your own copy of the bill and try to digest it as well. I would strongly recommend that. I want to start by commending DCA because the bill, although it passed in June, the governor didn't sign it until yesterday, and that's because DCA had a huge task. They have set up their website to allow tenants to do this self-certification. I tried it myself yesterday after I saw the reference in the bill, and I don't have to pay my rent. No, I didn't get that far, but the site is up and it is working, And it does ask just some simple questions, but it's important for every landlord to realize that one of the questions it asks is whether the tenant has applied for rental assistance. And that is an obligation of the certification process, because the tenant will not be certified unless they certify that they have made application for rental assistance. So that is an attempt to help the landlords who are looking to receive their rent. Also on the DCA website, and as the reference was given, nj.gov/DCA, they have very comprehensive FAQs, and both landlords and tenants probably want to refer to that website for very detailed information on different circumstances that might take place, and how the process works, how the courts will be notified. I noticed a number of questions in those areas, and if you refer to the DCA FAQs, you will get a good amount of information. And as I said, that is also where the tenants will go for their certification unless they make the phone call. So let's start with what can go forward now that the law has changed. Commercial evictions were already authorized to proceed several months ago, and I can indicate the courts are hearing commercial eviction cases even now. There is no moratorium against either the hearing of commercial cases or an eviction after a commercial case. The same with ejectments, which are not technically landlord-tenant, but are proceedings where the occupant is not a tenant and does not have a legal right to be in the property. Those actions are also proceeding and are not barred. The new addition from the law is that non-payment, and I don't know any better way to characterize these cases, but any case that is not a non-payment case, except for habitual late rent payment or rent increase payment cases, can go forward now as immediately. And so any cause of action that doesn't call for non-payment of rent can now be heard by the courts and proceed and move to eviction if the judgment for possession is granted. So I have to stop now and perhaps avoid many questions to landlord attorneys around the state and say that you need to be aware that in New Jersey, there are only 17 or 18 reasons why a residential tenant can be evicted. And it is important to realize that the end of the lease is not a grounds for eviction in the state of New Jersey. So to fend off the calls that I've been receiving that my tenant's lease expired during COVID or expired last month or expired a year ago, and now I want to do the eviction, don't bother to make the call. That is not a grounds for eviction. The legislature has specified certain reasons. They are very important reasons to proceed with eviction, such as critical things like destruction of property, but also violation of the lease agreement, habitual late payment, although that's non-payment related, that couldn't go forward now. But it's very important to be aware that the end of the lease is not grounds for eviction in New Jersey. So in non-payment, it's important to know a couple of different terms. First is the covered period. And the DCA representative did refer to that, but I'll mention it again. The covered period is March 1st, 2020 through August 31st, 2021. All rent during that period is effectively included in the bill. Now, whether that has any impact depends on this other item, which is household income. And household income, as defined in the bill, is the amount of money that the adults in the property are earning. And the DCA website, as was indicated, asks specific questions to try and develop the household income. It then does a behind the scenes comparison to the median income of the area where the tenant has indicated where they live. Just for an example, because I did not find any real good information on median income, even on the DCA website, a 4-person household in Atlantic County, the 80% median income is $66,350. The 120% median income is $78,250. Those figures are important for who can proceed with eviction and who can't. All tenants up to what's been defined as middle income, which is 120% of the area median income, can have all of their rent during the covered period converted to a civil debt and have any pending eviction action dismissed if they certify on the DCA website. So certifying, as I indicated, requires answering all the questions, giving all the income, and certifying that they have applied for rental assistance. According to the DCA website, if they have a pending eviction case and if they qualify and supply the docket number, the court will be notified that they have made a successful application and a dismissal will go forth from the court. That is what the website says, so I will assume that the process will work that way. Rents from before the covered period still are grounds for eviction for non-payment of rent, but the tenant may be covered by the eviction moratorium, which has not been completely removed yet, and I'll go into that in a minute. For September through December, all tenants up to moderate, which is 80%, are also protected from eviction for non-payment of rent, and their rents are converted to civil debts, again, if they file the certification with the website. Landlord's responsibilities, I'll go through this quickly, my time is running short. If the landlord receives a notice that the tenant has successfully certified, they cannot file an eviction case, even if they hadn't filed one up to that time. They are prohibited from filing an eviction case for non-payment for any rent during the covered period or for the September through December if the tenant has certified at the 80% level. As was indicated by the DCA representative in New Jersey, a landlord must accept and must cooperate with rental assistance payments and agencies. It is a requirement. Now, the state has added under this bill that to accept rental assistance, the landlord must also waive late fees in order to receive that assistance. But as was indicated and has been my experience with a lot of landlords, these are substantial payments that are being made in the tens of thousands of dollars. And certainly waiving late fees just to receive that money is a small price to pay. Landlords also cannot report non-payment either to other landlords or to credit agencies during the covered period or of rent during the covered period. That prohibition goes on forever. They also cannot consider non-payment during the covered period in future tenant screening for any tenants. And the bill also refers to a DCA notice that I don't believe has been generated yet, that has to be distributed to tenants and posted in multifamily buildings, but I presume we'll receive notice of that when it is available. Briefly on the moratorium, non-protected income tenants, which would mean either above the income level or if the tenants have not certified, Those evictions can proceed as of August 31st. All non-payment cases can proceed immediately if there are judgment for possessions in place, or once the court finishes, and if a judgment is granted, they can proceed immediately. For protected tenants who have certified, the moratorium does go until the original date of December 31st, and writ of possessions after foreclosure can proceed as of November 15th. Now, very quickly, I want to talk about the current process in court. The court, as part of the Landlord-Tenant Committee that Judge Grant referred to, adopted a modified recommendation that immediately, commencing with residential cases that are already on file, all parties must attend a mandatory settlement conference, again, remotely. My experience has been that once that notice is given, the tenants have been appearing. The purpose is not to proceed with eviction, but to help bring the parties together and reach a settlement, or to provide the tenants with information on rental assistance if they have not received it yet. The process is working to clear the calendar, and it will continue even with the new law. There will be cases that will not be covered by that, and there will be cases where the tenants do not certify. So it is important that the tenants do the certification, because those cases are moving forward. Landlords must file a case information statement as of September 1st, and all landlords are encouraged to use the Judiciary electronic document system, which can be found at newjerseycourts.gov, for filing their documents electronically, even though the courts are now opening up. That service is available to all landlords, not just attorneys. And that concludes my program. Thank you.
Attorney Thompson, thank you very much. We do have a number of questions in the queue that we will circle back to you on, largely in terms of landlords and what other options might exist for them with some specific nuances. So as I noted, we'll circle back to you on that. Next, I'd like to introduce Chief Counsel for Legal Services of New Jersey, Maura Sanders, who's going to speak about the rights and responsibilities of tenants. Attorney Sanders.
Thank you. Good afternoon. I am going to share a brief PowerPoint just to keep me on track as much as anything, and to hopefully give you another way of learning about much of the information that I think we all are talking about and want to make sure that you all are aware of. The first thing that we want to talk about, and that I really want to urge tenants and landlords for that matter, but tenants to recognize and pursue, is get legal advice. If you have a pending claim, if you have a pending case, if your landlord has threatened eviction, if you have questions about any of the procedures we've talked about, seek out legal advice. Legal Services is available statewide. Our Legal Services of New Jersey has a statewide telephone advice hotline. It gives free advice and information for eligible tenants. And I've got the toll-free number. You can also apply online and use our online resources. In addition to that, there are regional programs. There are legal services offices available for tenants in every county, as there have been for over 5 decades. To give you a little bit more insight of what that looks like, if you go to our website, you can find this information about how you apply for services and how you contact us. And this has information, both the hotline information, how you can apply online for services, our website where you can find all of the information regarding landlord tenant and what we're talking about, and how to find that local regional legal services program in your community. If you don't want to call the phone and get advice over the phone or follow up with us in another way. Just so that you can see, also on the website, you'll find this information, but we have offices in every single county in New Jersey, and there are phone numbers available as well for every office. Some of them have centralized intake, meaning that there's a central number to call. If you call us on the LS&J hotline number, we will also transfer and connect to those regional programs if you need further advice and assistance. Some of what you will find if you go to our website and you're looking for resources, we want everyone to be as informed as possible about the law, about your rights, to understand these issues, to read what's available, and then follow up with us, ask questions. On the very top of the page right now, you'll find there's an important alert, learn about landlord tenant and procedures and rental assistance programs. That will be the most up-to-date information that we post about what's happening with landlord tenant law. As Mr. Thompson just said, there were changes just yesterday. People were scrambling just to find that out. You all are hearing about and learning about some of these new changes today for the first time. We will have updated information about that as it moves forward, and try and keep that as up to date as possible through our web materials. Just to give you a little sense, this is what that page looks like, where the first page that you're going to go to about what's going on with updates in housing law, in court procedure, and all of that. This information will be changing daily at times. So check back if your question isn't answered and you want additional information, check back because it will be there. On the other side of the screen, you will see that little box for LS&J Law Hotline online intake. You can click that and you can submit your intake online, submit some general information, some basic information, and receive a call back from a legal advocate who will review your case with you and hopefully be able to answer your questions. If you need representation, we will connect you with one of the offices where we have direct representation. One of the other things that I really want to stress with this and that we will be doing, as you've learned, there's all this new process. There are new forms to be completed, new settlement conferences to navigate. Please give us a call. Please reach out to us about all of that. We are here to help with that. We're here to provide assistance with completing those forms. If you have any questions, if you have any issues, if you're unsure if you're going to be eligible, that's what we're here for. We want to make sure that people have access and are able to do it. For those of you who don't have access to reliable access to a computer or to a printer, if you're unable to do it on your phone or you just want someone to walk you through it, we're here for that as well. And we recognize that this is going to be a challenging process for many people. So it isn't just for you, but think about your neighbor as well. Is your neighbor going to need help in completing this process and going through the certification? Is there another way that they can connect with the system? Also online and available is our full tenants' rights in New Jersey manual. This is a fairly comprehensive document that goes through all of tenants' rights or most tenants' rights in New Jersey. As Mr. Thompson said earlier, there are multiple reasons for eviction in New Jersey, but they are specified reasons for eviction in New Jersey. Landlords have to have good cause. They have to serve proper notices. They can't evict simply because a lease expires. We urge everyone to sort of take a look, and that's an important resource that's available. There are other resources as well. We have that listed both on our website, the lawyer referral service, on the NJ court system. There are legal assistance organizations that are available in particular counties. There are organizations that help with specific people with specific disabilities or other issues. So we want to encourage that if you're not able to access our services or if there's other services that you're looking for, that information is also available. There are several out there. So when we talk about landlord tenant law, and what are we talking about right now? We've heard a lot about some of the new changes, which I will also go into in a minute, but want to go over a few things just broadly. Obviously in New Jersey, eviction is only for good cause. While the rules differ for some small owner occupied properties, for the most part, tenants cannot be evicted unless the landlord has a specified reason that falls within the Good Cause for Eviction Act. Even in situations where it's a small owner occupied property, there are still requirements for how you have to serve a tenant and give notice to a tenant before you can proceed with an eviction. Tenants can only be locked out by a court officer. Even after the moratorium ends, it's very important to understand and recognize that even without an eviction moratorium in place, evictions can only be effectuated by a court officer after there's a court order allowing for that eviction and authorizing that eviction to go forward. Tenants have defenses in eviction cases, in all kinds of eviction cases, even if there's unpaid rent. And for cases now during COVID, and because of this new law, that's even more the case right now. But even outside of this period of time, tenants who owe rent a year from now, tenants who owed rent 2 years ago, there are still some defenses in an eviction case. Is the rent properly owing? Well, there are other issues involved in terms of habitability that make the housing worth less than what was charged. Was the tenant overcharged because of rent control or other circumstances involved? In all cases, the landlords have to prove their case. The way cases go forward in landlord-tenant court, it's the landlord who files to evict a tenant, and the landlord must prove that case. There isn't an assumption when you walk into a courtroom or into a mediation session that the tenant owes money and the tenant has to pay or whatever it is. The landlord has to put on their proofs and the landlord has to prove their case before they're able to move forward and get a judgment for eviction. Settlement conferences, which we've talked a little bit about here already, and I'm sure you will hear more about from other members from the court. As noted, those settlement conferences right now are mandatory for attendance. This was not the case prior to a few weeks ago, but they are now mandatory. If tenants don't attend those settlement conferences, those cases will default, meaning a judgment can enter as long as the landlord puts on their proofs. If a landlord doesn't appear, the case will be dismissed. It's very important then that everyone understand that those conferences, attendance at those conferences is mandatory. Settlement, however, is a voluntary agreement. Obviously, the goal of this is to try and resolve issues and resolve problems, identify if there's outstanding problems and issues with obtaining assistance, if there are repairs that need to be made in the property and the tenant wants to raise that in an effort to try and get those repairs made. If they're going to negotiate around rent amounts, that's the purpose here, and there's a way to resolve this. The goal always in these situations, and particularly with what's happened over the last year and a half, really is to say, look, landlords need to be financially supported. Tenants shouldn't be evicted for circumstances beyond their control during a pandemic. We want to resolve it so that it's in the best interest of all parties whenever possible. But it's important to understand that you do not have to settle. We've been concerned because what we've seen thus far, unlike Mr. Thompson's experiences, I'm happy to hear that, and what he's seen is that most tenants and landlords have attended. In some counties, we've had reports of significant numbers of defaults, meaning tenants have not appeared. That can be because they don't understand that this is a mandatory process. It may be that they aren't getting notice to appear because it's sent by regular mail and they haven't received it, or they didn't know that it was something important. If you get anything from the court, you have to pay attention to it. It may be that they don't understand that there's been a change and that while these were voluntary at one time, now you have to appear. Or it may be that they think they don't have any defense and that they're just going to get evicted anyway, and so there's no point. Obviously, if you take away one thing from this today, it's to learn that you absolutely have defenses and that many, many, many of the pending cases out there right now should end up being dismissed. And as you've heard, rent and property owner assistance is available. More is on the way. There's this additional rental assistance coming. There's also additional assistance coming for property owners in small landlords in owner-occupied and other small housing dwellings. So what does the new law do and what does it say? The new law, it's Public Law 2021, Chapter 188. That's the specific designation for the law until it is officially codified and put into the statute books. Mr. Thompson said you can find it right now online as 3691. It's very confusing if you go and look for it in that form, however, because it has all of the crossouts and bracketing and other things that happen through the legislative process. It's, as they say, looking at the sausage being made. Very soon that will be published as something called a pamphlet law. It will have this title on it, this public law, PL 2021. That will be much easier to read and understand if you're looking for the version of it that is the actual final version of the new law and what it looks like. But I wanted to just include this quote here. This is the basic tenet of this section and what this law is dealing with, is that notwithstanding any other law to the contrary, of which we don't have that right now, but no residential tenant of a very low income household, moderate income household, or middle income household shall be evicted based on non-payment of rent or habitual late payment of rent or failure to pay a rent increase that accrued during the covered period. It's very clear what the law says, and tenants need to understand they have this right before they go into a settlement, before they decide that they're going to give up and move. This is what the law very plainly says. And when we talk about this, it's a little confusing because we're talking about two different time periods, and each one of those time periods has slightly different requirements in order to move forward and have that case dismissed. For rent due between March 2020 and August 2021, so rent due from the start of the pandemic through this month, those cases can be dismissed if a tenant can certify that they have income up to middle level income level, and it was for rent due during that period. Those are the only two requirements for rent that accrued during those months. For rent due from September 2021 through December 2021, you need to certify to additional factors as well. In those circumstances, you have to certify that you have income up to the moderate income level, which is the 80% of area median income. So it's a slightly lower income level, and that you have unpaid rent due to circumstances arising from the COVID crisis. And that, again, it's obvious if you know you lost your job. That's the easy one, right? You lost your job, you've been getting unemployment, or you've been going without. Obviously, you had circumstances arising from the COVID crisis, but it applies much more broadly than that. If you have other things going on in your family, in your household, many people had increased expenses during the pandemic. Food prices went up. You may have had children home from school and you had additional expenses paying for school supplies or other things that you needed to set up in your household. Those are COVID related expenses where you had to pay those things and maybe couldn't pay other bills. Your utilities may have gone up because you're using more electricity. You may have new internet connections in the house so that your children could go to school. You may have needed to rely on more expensive modes of transportation because of the pandemic. All of those are reasons that can be considered as circumstances arising from the COVID crisis. So think about that, and it's something that we can also provide advice about and assist with in filling out those certifications if you need assistance with that. And that is the end of that. I think the main thing really on this is to just understand that, you know, we all want to see these cases resolve. We all want to see rent paid and assistance provided. But we also want to make sure that tenants aren't evicted needlessly, and that everyone understands that there's help available. It's best to know what your legal rights are moving forward. And we are here. We are willing to help. We appreciate all the work that the court has done, that the Department of Community Affairs has done, and also that many of the landlord attorneys have done to move this process forward and to support a system that hopefully will resolve it amicably, or at least fairly for everyone. So thank you.
Thank you, Attorney Sanders. For the next two presentations, we'll now turn to court operations and services and programs. So we will next hear from Assistant Director of Trial Court Services for Civil Practice, Tori Phoenix, on current landlord-tenant court operations and related matters.
Thank you, Lisa. So good afternoon, everyone. I just wanted to share with you again what we're working on in terms of court processes currently. As has been alluded to earlier, we do have mandatory settlement conferences for residential landlord-tenant cases. The court authorized these mandatory settlement conferences in an order from July 1 of 2020. Parties receive at least 10 days notice, written notice of the date of the settlement conferences. And in that notice, it indicates that if a party does have a conflict, they should reach out to the court for the conference to have that conference rescheduled. Additionally, if a party has applied for rental assistance and their application is pending, the party can contact the court and request an adjournment. If they request that adjournment, you will just need to submit documentation showing that your application for rental assistance has been submitted. And if you know the status of that application, you can also advise of that. The court will give you a short period of time to submit that documentation so that we can provide the adjournment. Conferences will be adjourned for up to 60 days to resolve the rental assistance application. So a judge may also extend beyond that 60-day period if the parties agree, or if a judge determines that there are exceptional circumstances that exist. So this adjournment policy was issued by a notice to the bar today, which is available on the court's website. Additionally, this adjournment policy will apply for trials once trials do begin in September of this year. As others have noted, the primary goals of the settlement conferences that we are having right now is really to get the parties together with a neutral individual to try and help them assess the case, dispel any misinformation out there that's about any rental obligations that tenants have. Again, tenants are required to pay their rent. Also to advise landlords that you do have to cooperate with those applications for rental assistance. We'd also like to share accurate information about rental assistance programs and connect the parties to those resources that are available at the state, county, and local levels. As also was pointed out earlier, the parties are not required to settle their case, but importantly, there is no consequence if the parties do not settle their case. One thing that I do want to point out is that it is very important that you show up for the conferences when you do receive notice from the court. It's very important because, again, there is a consequence currently that if you do not show up for that conference, that's that mandatory settlement conference, your case could be dismissed. If you are the landlord or as a tenant, your default could be entered and eventually default judgment could be entered if the landlord proves their case. I wanted to touch base with you with regarding to dismissal of cases. As Ms. Winters from DCA indicated earlier, and also Mr. Thompson and Ms. Saunders have discussed that there is new legislation that provides certain tenants with protection from eviction. The judiciary will be complying with the requirements of this new legislation and will take whatever necessary steps there are to dismiss these cases where tenants file the required certification that has been prepared by DCA. I would like to note, importantly, that the legislation does not cancel rent, so landlords may be able to file an action with the court to collect unpaid rent from that COVID period. So tenants will receive summonses and complaints in those instances where a landlord has filed one of those actions for the unpaid rent. So that doesn't mean that you can't respond to that. If those summonses and complaints come in, again, I implore people to pay attention to the documentation coming from the court so that they know that they appear for various court events. If you have requested an adjournment of cases, you will receive a notice from the court indicating whether that adjournment has been approved. So please make sure that you get that before you choose not to show up for an event. Again, the court will work with you and you have to communicate with the court with respect to request for adjournment or to reschedule any type of event. I next wanted to touch base upon some of the new things that will be happening in landlord-tenant. Judge Grant indicated there was a special committee on landlord-tenant that made a series of recommendations to our Supreme Court, and the court on October 14th issued orders on the determinations on the, issued determinations on the recommendations. These reforms are at each stage of the process for landlord tenant. They include new and revised forms and information and materials for the parties. Some of those that I just wanted to touch base upon very quickly are landlords must file a case information statement, which provides the court with information regarding their case. Tenants will have an opportunity to provide information on a form about their case before trial, instead of waiting to the day of trial to be able to present any information that they have. We have additional court staff or legal specialists who will be performing enhanced review for certain cases, and they also will be conducting conferences, case management conferences with the parties. Again, our parties are going to be provided with opportunities to meet with our legal specialists to, again, discuss the case, attempt to try and work any issues that there are before those cases reach the trial stage. And lastly, I just wanted to note that we have clarified documents to the extent we can, just to give a better understanding of the process, provide people with a judgment for possession should an actual document, should the case get that far, so that they know what has happened and what are some next steps that they can take. So again, proceedings will be primarily remote, but I will indicate that we do have technology rooms in the judiciary. So if the person doesn't have personal technology to be able to connect to events, they can reach out to a special civil part office in the county where their case is, and they will work with them to provide them the ability to participate by coming into the courthouses and using one of our technology rooms. Again, all of the reforms that will go into effect in September of 2021. And for residential cases, as of now, trials will go forward in September. I want to note that Judiciary is aware of the CDC's order that was recently issued, and we will take steps to adjust as necessary with respect to that. Okay, and with that, I will turn it back over to Lisa.
Thank you very much. For our final direct presentation, we will turn to Passaic Vicinage Ombudsman June Cedar, who will provide information on litigant services and resources available through the offices of the Ombudsman.
There we go. Thank you, Lisa, and good afternoon, everybody. The Judiciary's Ombudsman program continues to provide direct assistance to court users in a variety of ways, particularly in this remote environment. The Ombudsman program has been in effect statewide since 2005, and in each of the last several years, Judiciary Ombudsmen statewide have helped over 77,000 court users each year, and the numbers continue to rise. Notably, 87% have been self-represented litigants. As a service to the community, the Ombudsman program is very helpful. During the pandemic, we have assisted with the implementation of the JEDS app and provided webinars to educate the community on court-related issues. As a Judiciary Ombudsman, as well as our trained staff, we are court employees, so we cannot give legal advice, but we can help in a variety of ways. We can explain court procedures to all members of the public, litigants or not. We can answer questions about finding and completing court forms, the investigation and resolution of complaints. We can guide court users to our helpful tools and resources on the Judiciary's website at njcourt.gov, and we can offer information about referrals to relevant state and local agencies and community service organizations, many that are represented here tonight. As our Ombudsman mission statement states, we are to promote an environment of continuous improvement in areas of court service and equal court access and compliance with court policies and procedures by establishing effective mechanisms for public information, community relations, and court user assistance. There is an ombudsman in each county, so you can reach out to your local ombudsman for resources in your area. Again, our information is located on our website at www.njcourts.gov. Thank you.
Thank you. Now, with our formal presentations having concluded, we're going to turn to our question and answer segment. Again, I'll remind you that you can drop questions in the Q&A box, where there is an option also to present your question anonymously if you wish to do so. Just be sure to click the anonymous option. We have over 140 questions submitted in the Q&A and numerous ones also submitted in the chat. I do want to note that I was reviewing them throughout, and there are a number that were actually answered by the presenters in the direct presentations. So in terms of the unanswered questions, I've done my best to group those thematically. And if there are any pieces of information like specific online resources and the like, we will provide those in a follow-up email so that you'll have that information as well. So to get started, we're going to circle back to DCA Director Janelle Winter. If you could just briefly clarify the information that you shared about the self-certification and whether there's any documentation required with that, what's required, how long the self-certification is valid for. And then the related question is in terms of how the lottery operates. There are a number of questions about whether it's a lottery done on a daily basis or on another time-specific basis.
Great, sure. So regarding the self-certification, this is the self-certification for eviction protections in the state of New Jersey that are offered by the bill that the governor signed yesterday. And in order to qualify for those, you have to file a self-certification form with your landlord, and if an eviction case is pending or is filed with the court. In order to do this form, you can go to the DCA website, you answer a few questions, and it generates a letter that you can use for the self-certification. You don't need to upload any information to the website. You just answer a few questions. The same if you don't have internet access and you do it through the call center, you'll be asked questions and you'll verify them, but you don't have to upload any information. Once you do the self-certification, depending on your income level, that governs what protections you might have. So for someone who is middle income, 120%, less than 120% of the area median income, the protections that are involved are any rent accrued during the covered period, which is March 2020 through August 31st, 2021. That is, you cannot be evicted for those arrears. But starting after August 31st, you can be evicted for other non-payment reasons. For those who are at 80% or below, and who also have suffered a COVID economic impact and assert that they've applied for rental assistance, in addition to those protections, also receive protection if you are unable to pay your rent in September through December 31st, 2021, and you also can't be evicted for other non-payment reasons through December 31st, 2021. And all of this information is in FAQs that are available on the website as well. And then regarding the lottery, once you submit your pre-application through the website, you are eligible for every lottery until you are selected for assistance or until we run out of funds, and we are nowhere near running out of funds right now. So you don't have to reapply. Once you apply, and you are eligible for every time until we select you. And we are pulling lotteries, so we are notifying thousands of people every single day. So if you have already applied and you haven't been selected yet, you don't have to apply again. You may still be selected. And we're doing that. We're selecting people and notifying them to send us more information every single day. So please, keep an eye on that. And if you're wondering if maybe you were selected, but you didn't get the email or something happened, you can call the call center or email the help address, which is available on our website, and ask about the status and see if maybe we are waiting for something for you.
For this next question, I'll start with you, Director Winter, and then Attorney Thompson may also want to weigh in. We have a question in terms of what role does the cooperativeness of a tenant or the consent of a tenant play in a landlord's ability to access funding? For example, can a landlord apply for available rental assistance if the tenant either will not or has not yet?
So in order for a landlord to apply on their tenant's behalf, they need the tenant's permission, and that's the federal funds that we're using require that. So that's a requirement. One thing that we've done in cases where a landlord has contacted us and they're having trouble with getting their tenant to apply is if they give us the tenant's contact information, we've reached out directly to try and explain the program to the tenant and encourage them to go ahead and apply or to give their landlord permission to apply. So we do try our best to make sure people understand the program and are willing to apply or allow their landlord to apply on their behalf if possible.
I would agree fully with that answer. I have had landlords indicating that to me. I would just point out that, again, the self-certification requires that the tenant, if they want to avoid eviction, requires that they certify that they have applied for rental assistance. So the consequence to the tenant would be that they will not be protected from eviction. So I believe that should be enough incentive for them to apply.
Thank you. So we have a number of questions relating to landlord's ability to potentially take other actions. So we have questions about remedies for landlords to collect on the debt if, for example, if there is a certain amount of rent due and owing, but the rental assistance has only paid off part of that, what is a landlord to do regarding the balance? Is that balance written off, or do they have to separately initiate a small claims action for that as a civil debt?
Most of the programs require that a landlord stop an eviction if they're going to accept the funds, but it doesn't bar them from pursuing civil action. And of course, if the tenant certifies and meets the income requirements, that would only be a civil debt in any event. So the landlord could pursue that in a special civil part. The law, I can point out, did direct the court to make available filing in the special civil part for any amount of rent that's due without limit. So that is a fairly easy way for a landlord to file a civil suit if they choose to do that.
And then a related question, Attorney Thompson, is if a landlord does pursue the civil route, where can they obtain information on how to actually collect on the debt, on the judgment?
Again, the court has a fairly comprehensive website, and it does contain information on trying to collect on a judgment after you've received a money judgment. There is a pamphlet available on the website that can be accessed at njcourts.gov under the Self-Help Center.
There's another question related to what somebody termed as a blended case. So where there is rent owing and then potential non-payment of rent reasons to remove a tenant. And the landlords were just asking for clarification whether they can proceed forward on those non-rent matters, or does the owing of rent and potential protection there prohibit the other component, if you will, of the potential action?
That would be for a judge to decide, but frankly, if the landlord has a cause of action separate from non-payment of rent and can prove their cause of action, I don't believe that the eviction would be stayed because non-payment cases are permitted to go forward at this point. Of course, the tenant would have defenses given that there's also non-payment as a component, and they should be raising those with their representative or their attorney.
Let me bring in Attorney Sanders.
Thank you. There are, just to follow up on some of what Mr. Thompson said on some of the previous questions regarding the issues around both applying for rent assistance and also about a landlord's ability to collect moving forward on that. Just to clarify the requirements under the bill, if the rent is for rent through August of this year, there is not that requirement that the tenant certify to those additional factors. Obviously, we want tenants to be applying for rent assistance. We're encouraging every tenant out there to do so. We want that money to get paid, but there is a little bit of a difference there in terms of when those requirements are in place. But primarily, I wanted to respond to the question about when a landlord is able to pursue. Obviously, landlords can file in special civil part and seek to collect on a debt. In those situations, tenants also have rights in those situations and can counterclaim. They can raise other issues in those cases if a security deposit was unpaid, if there were other expenses that they had, if there were habitability issues so that there were repairs that needed to be made, other issues that may have gone on in the property. So what's best for everyone is always in these circumstances, to the extent that you can, get informed, get legal advice. It's the best way for everyone to move forward on these whenever possible.
So that segues to two semi-related questions about access to representation. So one question is whether one needs to qualify for services through LS&J in order to avail themselves of the information hotline. And then the other is a notation that there seems to be broad access to representation or legal advice for tenants. Is there something similar available to landlords, particularly private non-corporate landlords?
So in order to qualify for our services, everything on the website is accessible. Many of the materials that are available on the website for everyone and for the public, both for landlords and for tenants. In order to qualify for advice and representation, you do have to go through our application intake and there is a financial eligibility requirement there as well. LS&J in particular, we have expanded our eligibility because New Jersey is such a high income state and the real true poverty in New Jersey is much higher than what would be considered the federal poverty level. So we've expanded our eligibility. So for our services through the LS&J hotline, that's higher, and we encourage most of the tenants that we are talking about here to go through that process. For additional representation in some of the county regional programs, some of them do not have the same eligibility limit that we have. It depends on a particular grant or service, but to get that initial advice through us at LS&J, first over the phone and then in person if necessary. We encourage people to take a look and see if they are. Generally, we're talking about, when we represent people who are low income, but as I said, we've expanded our eligibility criteria and it is maybe more than you think.
Attorney Thompson, did you want to mention anything in response to the question about representation or access to legal advice for landlords?
I'm not aware of any particular programs available to landlords, but again, I would encourage private landlords to access the njcourts.gov and their self-help center, which does have a large amount of information, as well as the legal services website, which, as Ms. Sanders indicated, is available to everyone.
And if I can, Lisa, just
Please.
Additionally, I just wanted to mention that, there are county bar associations that have lawyer referral out there, so they may be able to assist landlords with, questions or be able to assist them with these cases.
Thank you. I'm actually going to take this opportunity to ask a number of questions have come in requesting clarification on the terms eviction versus ejection and adjournment versus dismissal. If somebody could just briefly comment on those for clarification, I think the audience would appreciate it.
Well, I'll take eviction and ejectment first. Ejectment is only for non-tenants who are not and never were a tenant, who don't have a right to be in the property. The best example is, unfortunately, in New Jersey, if someone breaks into your residential property and starts living there as their residence, the only way you can remove them is through an ejectment proceeding. But if you've ever had a landlord-tenant relationship with the person in the property, even if they haven't paid rent forever, but they were originally your tenant, a ejectment action can't be brought against them. I'll leave court staff to the adjournment dismissal question.
So in terms of an adjournment, that's basically like a postponement, which means the case would still be pending, would still exist, but we're not going to deal with it right at that particular time. It's asking for more time to handle the case for whatever reason. So it's basically a postponement, putting it off to a later time. With respect to a dismissal, that means that the case is done. The case goes away, case doesn't exist anymore. Hopefully that kind of clears it up. I don't know if Mara or Bill want to add anything, but that's pretty much the distinction.
Thank you. So these are a couple of, we'll just say, theme-specific individual questions. There's a question as to whether the immigration status of the landlord or the tenant is at all a factor, either in terms of eligibility for the assistance or in any of the procedural requirements.
I have to say, on the landlord side, there, at least interfacing with the court, there's no prohibition on or even assessment of status in that regard.
I thought Janelle was still on, but in terms of assistance and what goes on with assistance, there are some limitations on certain rent programs for individuals who do not have what's called an eligible immigration status. It may mean that they are here with some status or no status, but for some programs there is not, but for other programs there is not that same limitation. We'd urge you to apply. And if there are questions about that, please reach out to us as well, and we can provide further guidance on what assistance programs you may and may not be eligible for in that circumstance. The other thing to consider in those circumstances is many times in a household, there may be a family member who does not have an eligible immigration status and another family member who does, who can apply for assistance. So even in those circumstances, if there's limitations, it's something that we can advise about, and we're happy to do that.
Thank you. A couple of other questions. There's one question as to what's the authoritative source to refer to in terms of median incomes for the respective areas? I don't know if anyone can speak to that. And then another question is, we know that we have quite a few representatives of public housing authorities in the audience today. So just if you could, if there's any particular nuance or ways that public housing authorities are impacted by the new legislation or any of the procedural requirements that have been discussed, if you could just briefly highlight those, it'd be appreciated.
Sure. So the area median income figures are determined. The Housing and Urban Development publishes that information and those numbers. It's based on data and information collected. I can't remember which of two studies that they get that data from, but it does come from there, and it's available there. I know that the 80% of area median income is available on the DCA website right now. Additional information is available on the HUD website with that information as well. And the second question was
with regard to public housing authorities or any landlord that accepts Section 8 and that type of funding.
One thing that it's important, and one reason why I make that distinction about the differences in the law on this, and to be clear, for rent due through the end of August, the only criteria is that you are have income below middle income or below, and that the rent was due during that period. There isn't that other criteria. So tenants who are in subsidized housing are always, there isn't a bar on that. There isn't a bar going forward for any of these programs. The federal government issued additional guidance recently around the rent assistance program that this funding comes from, and the federal program that where much of this funding comes from, to clarify that tenants in federally assisted housing, tenants in subsidized housing can still apply and be deemed eligible for assistance. So there isn't a bar on their applying for or receiving assistance as long as they meet other criteria and can demonstrate hardship.
I am mindful that we are at the 5:30 hour, and we had published that the program would run from 4 p.m. to 5:30, and we want to be mindful of the panelists' time as well as the attendees' time. That said, we're also mindful that there are some questions unanswered. So I do want to assure everyone that in follow-up to the program, we will provide an email tomorrow that includes the URLs, the telephone numbers, the other resources that the presenters have referenced. In addition, where we can, we will include responses to the questions, to the general questions that have not been answered. We did note that we're not able to provide information or responses to individual case circumstances, but we can include the general resources to which you can refer for further information as well. So on that note, I'd like to do just one go around to the panelists in case you have any closing thought or maybe top 1 or 2 takeaways you want to highlight to the attendees. And I will start with Attorney Thompson.
Thank you. I believe the information was fairly comprehensive. It's just everyone, landlords and tenants, need to be aware that this is brand new. We're all working our way through it. And I would encourage unrepresented parties on either side to try and get some type of legal representation to assist them with these difficult issues. The court tries to help as best it can, but they can't answer all the questions. So we just have to keep working through it. And thank you.
Thank you. Next, I'll turn to Attorney Sanders.
Thank you. Really want to thank the court for going forward with this presentation and for all the work that's been done over the pandemic and particularly over the last few months to move forward in a very challenging time. What is extremely important here is that all of these agencies are working together and talking together and coordinating going forward as well. All parties don't give up. And if you run into roadblocks or bumps in the road, please raise it, please bring it up. Because these are all new processes, we want to make sure that everyone is heard and that those issues are addressed as they come up. There may be unintended consequences all along the way, and want to make sure that that's addressed. So I'd urge everyone to keep communicating and keep moving forward, and let's hope that we can get out of this pandemic at some point.
Thank you. Tori Phoenix.
I see Judge Grant is here, so I'm going to defer to Judge Grant with any.
No, Ms. Phoenix, you can
remarks.
close. I'm thankful for all the panelists. Appreciate the attendees. For me, again, we are in this extraordinary period of time in our society. And what you see in New Jersey is at least government, the private sector, agencies, nonprofits, all coming together, trying to save our communities. And that means both landlords and tenants. And so we're appreciative of this opportunity to discuss these matters. As I said, this will not be the final virtual conversation we'll have on this topic. We'll have other conversations. Some of them will be local. I see many people in the chat, as Ms. Burke has indicated. We will try to answer as many of those questions as we can to get back to you. And I want to thank Lisa for her great moderation of the program. So thank you so much.
Thank you, Judge Grant. And on that note, we will consider the webinar concluded, and we will provide the follow-up information as promised. Everyone stay well and have a good evening.
Thank you.
Thank you.